And Kevin Kline, I learned a lot about Kevin Kline. One thing I learned about Kevin Kline is that he likes to walk around with his rowboat. For me, I learned more than I needed to ever know about
Wow.
Mr. Kevin Kline.
Hey, besties. Blake Lively's attorneys waited until the end of business, the end of the court day, in order to drop what they decided to do about this audio. The audio that Blake claims includes statements by Steve Sarowitz about how he was going to spend $100 million or such to destroy her. And this audio, which was recorded without the consent, apparently, of Steve, by Claire Ayub, who is a director and writer of the film Empire Waste that was produced and released by Wayfair Studios in the fall of 2024. This was evidence that Blake Lively's attorneys had, that they opted not to file with the court when they provided this to the court months ago as a part of their motion for sanction or motion for treble damages and punitive damages under 47.1. They never provided a copy to the court. The letter today that was filed by them, it makes clear that no one at the court has ever had a copy of this, including the judge. No one, not a single person. Earlier this week, the judge noticed that and told them, listen, we're getting requests about this audio that was on the docket that I unsealed. We don't have a copy of it. You need to tell me what you're going to do so that we can get this out to the public. So their response letter says, in accordance with your Honor's October 15th, 2025 order, plaintiff Blake Lively and defendants Wayfair Studios, and then they name all the parties, respectfully write to inform the court of their efforts to publicly release the audio files submitted in support of Ms. Lively's motion for fees and damages under California Civil Code 47.1, which the court previously ordered unsealed. The parties have conferred and agreed to provide the clerk's office with copies of the physical audio recording in a CD format, which will then be distributed to or copied for the public upon the clerk's office receiving such request. Counsel for the parties confirmed that the clerk's office is amendable to the foregoing approach, which the parties agree provides public access to the audio file in lieu of the file being filed on the public docket, which the court's docket cannot accommodate from a technical standpoint. Counsel has received limited outreach for the audio file to date and intends to provide a sufficient number of copies to accommodate any anticipated requests to the clerk's office and will also provide additional copies as needed. That's what their agreement is. We are going to provide a copy of this via CD to the clerk, and the clerk is okay with this method. What I find ironic, though, and strange is like, why didn't you give a copy of the CD to the clerk when you filed the motion to begin with? Had you done that in the beginning, we wouldn't be here today. And how was the judge supposed to review the audio in the motion without a physical copy? I just have so many questions here. So what I think is really strange is that, generally speaking, in order for them to admit an audio recording into federal court, it needs to be authenticated to make sure that it hasn't been doctored, that the chain of custody is clear, and so that you know that the audio recording you're hearing is accurate. So generally, if they're going to file an exhibit like this into the courtroom, they would need to create a sworn statement that authenticates the recording. So it should detail the method of the recording, the chain of custody, and the accuracy of it. A written transcript is crucial to help the judge and jury understand the audio. You can use standard digital audio formats like MP3, WAV, or MP4 when you upload, so you can use electronic means to upload. You can also provide a physical copy of the CD, but generally, when submitted to the court, you would not just submit a copy of the CD or the physical, but you would also file a copy of the transcript along with the chain of custody so that the court knows that this has been verified. Without that, we don't even know. It could just be hearsay. And really, all Claire says is that I recorded this because of X, Y, and Z. So maybe she's trying to authenticate it, but she did not say the means that she used to record it. She doesn't say, I recorded it on my phone. I used a tape recorder. She doesn't say how it was recorded. Did she record it with voice memo? Was she on a Zoom call with him and recorded the Zoom call, right? We don't know how it was. And another thing I was thinking about is even if the audio is revealed and released into the public, we don't even know if this is admissible in court. Like, we haven't even gotten to the point in the trial that once this comes out, right? This may not even be allowed at trial. They would have to determine that it's relevant to it's relevant to the case, that the chain of custody was followed, that it's authenticated, that it hasn't been tampered with, that it was legally obtained or submitted. And what I think is just really odd is that, Wayfair isn't fighting this. They're saying release it. So maybe they're admitting that it's real, but even so, even with it as an exhibit, this is simply an exhibit. This hasn't been ruled as evidence for the trial. It hasn't been admitted as evidence for the trial. In order to go to that step, they're going to have to go through much longer lengths to make sure that it's going to trial. Right now, it's simply an exhibit that they're using to support a motion. And interestingly, the judge issued 2 orders here that kind of coincide and overlap with this issue related to the New York Times wanting a final judgment, which right now the judge says he doesn't think it's the appropriate time for that. And he's telling the New York Times that their dismissal is already final in that they've been dismissed. But right now, there are still outstanding motions for fees. And he's asking every single party in the case to respond to him about what motions are outstanding, whether or not those motions mean that the case is still open, and he'll make a decision on whether or not he can discharge New York Times. But he stated that the Times motion is predicated on the mistaken notion that the court's order dismissing the complainant in this case will not become final until after a final decision is rendered in the Lively action. The court consolidated this case with the Lively action, but the effect of that order was not to make the time to appeal a final judgment in this case run from a final judgment in both cases. Rule 42 does not have such an effect. As the Supreme Court has clarified, even when cases are consolidated, constituent cases retain their separate identities, at least to the extent that a final decision in one is immediately appealable by the losing party. They need to show cause as to why this should be ordered. He also wants them to respond to whether or not having open fees motions means that the case is not final. So all the parties have to respond to whether or not they agree or disagree about whether or not this isn't final, or if, the case can be discharged for the New York Times, because he would essentially be discharging it for everyone. With consolidated cases like this, often in federal court, they don't usually like to do motions on sanctions or fees or such until the very end when all the cases are resolved. In the case of the New York Times, they're sort of separate from everyone else. So we'll see how they respond in that. When it comes to if we circle back to what's going on with the CD, the judge told Blake that she has until Monday to provide a copy of that to the court. So she has until Monday, October 20th, to provide a copy of the physical CD, no later than October 20th, 2025. So again, what I just think is odd about all of this is that Blake's team should have filed the CD or provided a copy of the CD to the court immediately when they filed the document, and they didn't. The way that they're choosing to file it with a physical CD, which gives the CD directly to the clerk, and then the clerk has to make a copy, it's not the most accessible way for individuals to get a copy of the technology from the court. Generally speaking, you can 100% share a WAV file or an electronic file with the court. You don't need it to be on a physical CD. Accessibility is decreased when it has to be physically mailed, but It's not the first time something like that would happen. So ultimately, it's just creating a few more steps for individuals. Like, you're going to have to physically go to the court. You're going to have to request a copy of it from the clerk. And then the clerk will charge you a fee to give you a copy of the CD. And then once you have the CD, you have to have a CD player, which not everyone has. I do have an attachment on my computer, but I'm definitely not going to be making a request for this audio simply because I'm in Minnesota. I don't have time to get to New York to go to the clerk to request this. And snail mail would take forever for it to get to me. So it's probable that there's someone on Reddit that will run down to the clerk's office on Monday or Tuesday, get a copy, and upload it online. You know, Blake's team could have easily they could have decided to release it publicly together. They could have just said, we're going to put it on a WAV file and we're going to post it on this website, right? They could release it right now publicly if they wanted to. Maybe they have fear that if they do it themselves, they could be breaking the law because there's questions now about whether or not it was legally obtained. So by giving it to the clerk, it's out of their hands and the distribution of it is through the clerk, not through them. So their hands are off, any questions about the legality of it. But it just seems sort of ridiculous that they didn't provide this to the court when they filed the motion. And it makes me question if they ever really truly intended for this motion to be anything more than simply a PR performative stunt. Because one would think, and I'm currently being sued, when you provide a document and evidence to the court, you file it the same day as you file a motion. You don't hold off on filing it because it's under seal. You don't withhold it from the court. The court relies on your evidence in order to make decisions. And the court and the judge, they don't have access to your discovery. Discovery that happens between parties is behind the scenes, and the judges don't automatically get access to the discovery files. What's eventually admitted into the court as evidence goes through the process of the motions that happen in limine, which basically are we going to try to get things out and not allowed into the court? So admissibility and all of that doesn't happen until later on. So judges don't just get access to the discovery file generally. And documents that are under seal that are on attorney's eyes only, defendants don't get to see. So if they filed this under attorney's eyes only, it means that until it was unsealed, Sarowitz didn't get to hear it. Baldoni didn't get to hear it. All these people didn't get to hear it. And that means also that until it's provided to the court, it's still technically under seal in that nobody's seen it yet or heard it yet. So everyone's kind of just waiting. The attorneys have seen it. Wayfair's attorneys have seen it, but they may not even have a physical copy of it yet. We don't know. So that's where it's at right now. I still think it's just weird in this day and age to use a CD, but whatever. Maybe it's just their way to make it an obstacle. So yeah, Monday it will be at the court, and whoever gets it, I think there's someone named Clark on Reddit that's going to be going to the court as soon as they can on Monday to get it. So it'll be online soon. What's contained in the audio, whether or not it's relevant, even if it'll go to trial, that remains to be seen. For the motion, she's claiming it validates that there was a conspiracy to take her down. And we'll have to see if the audio proves that conspiracy. Tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.